So let's go ahead and begin with Chapter 1. Chapter 1 of your book is the License Law chapter. And Chapter 1 begins on page 1. And we call the Real Estate License Act 2000 the Act. So when we refer to the Act, we refer to the license law, the Illinois Real Estate License Act, year 2000. The Act is the law that regulates the competency of real estate practitioners and their practices for the protection of the public. It's enforced by the Illinois Department of Financial and Professional Regulation. We'll refer to that as the IDFPR. Notice as we go through each of these slides, I will have and cite the page number of the slidecast that we're going to be talking, so you can follow page by page through your slidecast and not get lost. On page 2, we find who needs a broker's license. Notice I have individual in a highlighted color. Certainly there are, if you will, corporate forms of real estate brokers' licenses. Not people, but entities. An entity as a corporation, an entity as a partnership, an entity as a registered limited liability partnership, or an LLC company. We'll kind of come back to in just a little bit when an individual holds a broker's license, what that means. It gets a little confusing now because what we used to think of a broker's license now as somebody who was the, someone who ran a company could run one as an individual as a broker. We actually have a separate license for individuals called managing brokers. So corporations can hold broker's licenses, and you as brokers/salespeople can have broker's licenses. Individuals who manage offices have a special kind of broker's license called the managing broker's license, and I hope that's not too confusing for you. Who needs a broker's license? Anyone or any entity who participates in these listed real estate activities found on page 2 for another and for compensation, or with the intention of expectation of receiving compensation, either directly or indirectly. So on page 2, if you look at those 11 categories they have there, any one of those individuals or entities that engages in this kind of activity needs to be licensed. Of course, we're going to have some exemptions. And this, by the way, includes sales activities, any leasing activities, any 1031 exchanging that you are involved in, any timeshares are examples of the kinds of activities. If you engage in those activities for others and are paid, then you need to be licensed. What are our exemptions? Our exemptions are found on pages 2 and actually page 3. And these would be an example of a couple of the more important exemptions. If you look on page 3, you'll see a whole list. 2 and 3, you'll see a whole list of them. But the more important ones are attorneys acting under a power of attorney, state or federal employees performing official duties, newspapers who are just advertising listings, they're not actually marketing them, executors in wills, or individuals appointed by a court under a probate to administer the disposition of real estate for a decedent would be exempt, and resident property managers are exempt. This is kind of a little weird little exception, but you can actually work for a real estate company as a resident property manager in one of their apartment units, and as long as you reside there working for that company as a resident property manager, you don't have to be licensed. However, if you move and you're no longer a resident of that apartment complex and you continue to manage that apartment complex, then you will have to get your broker's license. Multiple listing services, as long as all they do is exchange information, don't have to be involved. If for some reason a multiple listing service would also be engaged in the activity of bringing sellers and buyers or landlords and tenants together, then they would lose their exemption and have to be licensed. I don't think most MLSs are interested in actually marketing property, so they maintain their exemptions. If you're someone who is unlicensed and you do engage in activities and you're not exempt, you could be fined a $25,000 civil penalty per each offense for the unlicensed practice in real estate. So the IDFPR can actually fine unlicensed people once they start engaging in these licensed activities and are in fact not licensed. As we said, these are the different kinds of brokers, the different kinds of individuals that can have brokers' licenses. Individuals can, and corporations and partnerships can. With managing brokers, we have the individuals that are in fact running the operation, the brokerage operation on a daily basis. Underneath the managing brokers, we have these people called brokers, which is what you are now, if you will, the old salesperson's license. And if you're a self-sponsored broker, you're also the managing broker. So the managing broker, having a broker's license under being self-sponsored, that means they're not under a corporate type of ownership, they're under a sole proprietor ownership. So the managing broker is also called the sponsoring broker. And of course, under our managing brokers, whether it's a corporate structure or a sole proprietorship, we have the different licenses. We have the broker's license, we have the leasing agent license, and we have licensed sales assistants. So those are the different kinds of licenses that a managing broker could have as a self-sponsored or sponsoring broker. As a leasing agent, remember, only residential leasing agent activities can the leasing agent engage in with that limited scope license. Only residential leasing agent activities. They start leasing commercial properties, they have to get a regular broker's license. They lose their exemption. A broker, as an individual in a real estate office holding your broker's license, you can now form a corporation only to receive dollars, only to receive commissions. So we'll allow individuals that are licensed as brokers to actually hold a corporate ownership, but they must be the only sole shareholder in that real estate broker corporation. And when we say real estate broker corporation, this is not a corporation that is licensed to engage in the business of real estate, only to hold the corporate charter for an individual so that that individual can accept monies through the corporation structure, not through their own structure. And of course, this has tax consequences, doesn't it? The licensed sales assistant is someone then that holds a license that is licensed through the managing broker. Unlicensed sales assistants can only be employed as employees, and unlicensed sales assistants can never receive commissions. Licensed sales assistants can receive commissions. Licensed sales assistants can also be employed as independent contractors. The new broker requirement, what is it now? If you had to start all over again, which you don't want to do, you'd have to be 21 years of age, good moral character, high school diploma, completion of 90 hours, and that 90-hour course that you take now is broken up into two pieces. It's a 75-hour principles course and a 15-hour interactive class. Then you have to take and pass your written broker's exam. You apply for your license after you've done that. You get your 45-day sponsor card permit. While you're waiting, you can practice. And then when your real license comes, you hang it up on the wall, and of course you put your pocket card in your pocket. It is important to know that the new broker license requirement requires another 30 hours of post-license education before the first renewal. So since May 1, when the new requirements came into place, all of our new brokers have been taking their 90 hours. All of our new brokers are going to have to take an additional 30 hours prior to April 30th of 2012 when they go to renew their broker's license for the first time. So the real requirement for new brokers is a total of 120 hours. 90 now, 30 later. This new managing broker license requires someone, now the managing broker of course is the same as a quote sponsoring broker when it's an individual, or the managing broker is the individual that is licensed to run the corporation that is licensed as a broker, or LLC. The individual must be 21 years of age, good moral character, licensed 2 of the preceding 3 years, either as a broker or an old salesperson's license, doesn't matter, but before you become a managing broker, you have to have had some experience in the real estate business. You complete 45 hours of educational requirements, which includes a 15-hour interactive course. So the requirement is a 30 plus a 15-hour course, the 15-hour being the interactive course. Take and pass your state managing broker's exam that AMP gives, and then you apply and pay your fees. You get a 45-day sponsor card permit. While you wait, you can be actively involved as a managing broker. In fact, the new requirements allow you to act as a managing broker for 90 days while you're working on being a managing broker. Disclosure issues, a lot of this chapter goes through disclosure issues, and there they are, pages 5 through 18. I'm just going to hit the highlights that I want you to know. Make sure that you don't call them your client while you're working with customers, because if you start calling them your client, there will be an implied agency that you are their client and you're going to owe them those duties, and if for some reason you don't, you might get yourself involved in a lawsuit. They will have an action against you for basically holding yourself out to be their agent and not representing them as their agent. Dual agency, if you do represent as an agent 2 clients, let's say the seller client and the buyer client, make sure they both get informed written consent and that they sign a disclosure and consent to dual agency form. So it's not enough just to tell them in writing. They also have to give their consent in writing. If you represent both, then we have a dual agency. Must give the parties written disclosure and consent before you act. So make sure that they get that. And your book has got these forms in them. If the parties do not want at any time after agreeing to that you're being a dual agent, if afterwards they change their mind, either party can withdraw at any time. Compensation, you can only be paid money by your sponsoring broker. Any money that comes to you must go through them first. In a nutshell, period, sort of end of story. We can't pay unlicensed people for real estate activities that would require a license. A broker to co-op broker is okay, so your sponsoring broker can pay a co-op sponsoring broker, and of course can pay you. It should say managing broker to a co-op managing broker is a better way of expressing what we just see there. Special interest disclosure. You must disclose your status as a real estate licensee if you have any interest in the deal. So if you're going to be buying property on your own behalf or you're selling your own property, once you're licensed, you must notify all parties in the deal that you in fact are licensed. You put it right on the listing contract, put it right on the sales contract, put it right on the lease. You are a licensed, an Illinois registrant, Illinois licensee, Illinois broker, Illinois managing broker. You pick the terminology, but it must appear on those documents in any deals that you're involved in. Material facts. You have to disclose to all parties in a real estate transaction any material fact that you have knowledge of. A material fact is any fact that would affect somebody living in the property, the habitability of the property. You must disclose any that you have knowledge of or probably should have knowledge of. You must even disclose these to unrepresented customers. Even though a customer comes to you and you're not representing them, you still owe them the duty to disclose hidden material facts that they must know of. And tell them this in writing. If you represent both, of course, in dual agency, both parties must be given disclosure of and knowledge of any material facts that you have knowledge of. Stigmatized properties you don't have to disclose. A stigmatized property is a property where there is a defect in the property, but it doesn't affect the habitability of living in the property. So just because there may be ghosts in the property, poltergeists, maybe someone had a serious disease in the property, you don't have to disclose this. And certainly, not only do you not have to disclose that someone had HIV, that let's say the seller had HIV, but in that event, you would actually be violating the Fair Housing Law if you did it. So not only do you not have to do it, you literally can't do it if the serious illness was HIV. And again, your property with stigmatized properties talks about a couple of the other kinds of things that would be classified as stigmatized property that you'd have to disclose. So you're protected. If someone comes back to you later and say, hey, you didn't disclose this to me, that was a material defect, and you would say, no, it's a stigmatized defect, not a material defect. Speaking of disclosure, let's look on pages 10 and 11 where we'll see figure 1.4, which is the residential real property disclosure form. This is a disclosure form that's to protect sellers, buyers, and maybe as importantly, you as agents. This form is to be filled out on any deal where you got a 1 to 4 unit residential property, a single family or a small 4-flat. The seller completes this form, of which there are 23 statements regarding the structural, mechanical, and other conditions, and to the best of his ability or her ability, they complete the form. The form is available to buyers before an offer is accepted. If the buyer finds any negative results from the disclosure form, they can back out and get their earnest money returned. If the seller finds any new ones after, say, the sales contract was signed, then the seller must update the residential real property disclosure form in writing and give the prospective purchasers the new updated form. Don't advise or help your sellers complete the form. If they have any questions for it, either talk to your broker or have them talk to their attorney as far as their response to this. But you should never advise or help sellers. The whole idea is that they do this on their own without your input. If you do any input with the sellers or buyers, you might be held equally liable if there is a defect in the property. The form, by the way, is both pages, both page 10 and 11. It's not just the check boxes that they've got to fill out there. So make sure that when you're giving buyers copies of this, you include both forms. Most agents, I think, actually have this form completed, and they include it with their, with the listing sheets at the property, or any material that they have at the property, marketing material that they keep at the property. So as individuals are going through showings with their buyer agents, the form is already completed there, so they get it almost from the very beginning. So that's probably good practice. But talk to your broker about the best way he wants to handle the residential real property disclosure form. But it is a good form, and I do want to point out, don't you help the sellers complete the form, and it's really there as much for your protection as for the sellers and buyers' protection. So use that form and get familiar with it and use it as a good tool. Lead-based paint. Anytime you're dealing with a property, either representing someone who's purchasing the property, or if you're representing a seller of property built after 1978, you must be aware of the potential presence of lead-based paint, and you must give them disclosures. These disclosures go to buyers or to tenants. You give them a form, lead-based paint form, and they also get a lead-based paint pamphlet. So be familiar with those. I'm sure they're in your office. Read them through if you want, but it's your obligation as an agent to make sure that your sellers and or your buyers get these quote disclosures on any property that might have the presence of lead-based paint. If buyers want to, after they receive this disclosure, they have 10 days to conduct an inspection. Lead-based paint then. Agents must keep any lead-based paint disclosure statements then that you give to people, you keep your copy for at least 3 years after the deal is over. With radon, sellers must give a disclosure of information on radon. It's called a disclosure of information on radar hazards form, so that's a form that sellers must give. And again, there's a pamphlet that goes with that explains to buyers about testing guidelines. Radon and radon inspection and radon disclosure does not have to be made to any property that is above a 3rd floor. And of course, here we're talking about condos in particular, or perhaps apartment complexes, apartment units. Violations of the Act. If you violate the License Act that we started talking about before, and all those provisions that we told you to kind of read through as you go through the course there in the earlier pages 2 and 3, anybody who violates any of those, the department can refuse your license. They just don't give you one, or they revoke it when you already have, which means you're technically out of business until you can get it back, or perhaps they reprimand it, which means you get to keep it, but they'll fine you. Maybe they'll make you take a course. Maybe they'll keep you out of the business for 6 months or so and then let you back in. So they have the opportunity to refuse license. They don't give it to you. They don't renew it for you. They revoke it while you've got it, and then you either lose it permanently, or you can sometimes appeal to get it back, or they reprimand your license with a fine or other penalty and allow you to continue your practice. It can fine you up to $25,000 for any occurrence of any violation of the Act, so that can be pretty steep. Even if you're licensed in another state and you're licensed here too, they can discipline you here. So if you have an action against you in another state and you're licensed, you can also have that affect your Illinois license. Violations of the Act include non-payment of Illinois child support, non-payment of Illinois student loans, non-payment of Illinois income tax. So in order to renew your license, in order to upgrade to your broker's license, you'll want to make sure you're not 30 days in arrears in child support, and you're not in arrears or behind on Illinois student loans or Illinois income tax payments. If you offer a guaranteed sales plan, most offices don't. Years ago, this was kind of a big thing to give. A guaranteed sales plan is where when you're listing property, you say to a seller, and seller, if we can't sell your property, we'll buy it. We'll guarantee that we'll buy it from you. It's fraught with some problems. I would strongly recommend that if you are involved in guaranteed sales plans, you approach them with caution. Make sure your managing broker, your sponsoring broker, managing broker has all of the details in writing to give to the seller, that the managing broker or that corporation has dollar evidence to show they can complete the deal, in fact, if they have to. And make sure that when you're marketing that property, you market a property that has a guaranteed sales plan on it, just like you would with properties that don't have guaranteed sales plans. So take your Chapter 1 agency review quiz, and when you're done with that, go back through the chapter or through the chapter reviews that we have online for you. And if you have questions on any of the things we've talked about, certainly give us a call and make sure that we're on the same page and you feel comfortable with all the material there. And then proceed on to